SJC-12808, Commonwealth v. Corey Evelyn.
Ms. Barnwell, good morning.
Good morning, Mr. Chief Justice, and may it please the Court. My name is Hayne Barnwell, and I represent Corey Evelyn. With me at council table is Attorney Janice Bassil. In any suppression case, whether the court is analyzing when a seizure occurred or whether there was reasonable suspicion for the stop, the court, of course, considers the totality of the circumstances. However, in this case, the Commonwealth wishes this court to ignore two significant circumstances. One is that Mr. Evelyn is a young black male. The other is that the other significant circumstance is the reality for young black males in Boston. As this court recognized in Commonwealth versus Warren, and that's nearly 30 years after Charles Stewart's hoax triggered a wave of illegal searches and seizures in Boston's black community. Young black men are disproportionately targeted by the Boston Police Department for FIOs, which include humiliating stops and frisks. The Superior Court also did not follow this court's direction in Commonwealth versus Warren. And actually, there were two directions in Commonwealth versus Warren. The first being that a person's flight should have little to no weight in the reasonable suspicion analysis, given the fact that people are free to avoid police officers.
Well, Counsel, I would like to, in general, I understand your broader points and the broader statistics. I'd like to focus more narrowly on this particular case, and I'm wondering what, if any, factors would distinguish it from Warren?
What if, well, actually, I'm sorry, is the court focused on seizure right now or on reasonable suspicion?
It's a difficult question because let's first focus on the seizure because they relate together. Yes. They're hard to separate those two things in my mind because if there's no reasonable suspicion, then it changes when the seizure is. So let's focus first on because certainly you agree a police officer can stop somebody on the street and say, I want to ask you a question. Mm-hmm. Especially in these, and let's focus on these circumstances, which are what again?
So the circumstances here is we have a black teenage boy. He's alone. He's walking on the residential street in Roxbury. Two white Boston police officers. They are in full uniform in a marked cruiser. They shadow him.
And why? And why were they there?
That's an excellent question. What the officers testify to is that they get a shot spotter call. Okay, as they're on patrol.
A shot spotter call came in within what radius of where they were?
Half a mile.
Half a mile, about half a mile.
Thank you, Counsel.
I'm just trying to recall where they exactly were when they got the shot spotter, but they were, I would think, around half a mile.
A half a mile. And how
correct.
Much time had passed between the shot spotter and when they were located?
When they first see Mr. Evelyn, it's 13 minutes after they get the shot spotter. Okay,
so let's stop with that and then go to Warren. What were the facts in Warren that are similar?
So in Warren, the officer interviewed the victim apparently very quickly. 20 minutes later, they see the defendant, and then 25 minutes later, they stop him.
And what was the distance?
That was a mile.
Okay.
A mile is my recollection. And just to quickly turn to Commonwealth versus Cheek, in Commonwealth versus Cheek, that was actually a half mile.
Okay.
So that's even more similar to
So let me ask you, another question I have is, when the police approach, do you consider that to require reasonable suspicion at that moment?
No. Reasonable suspicion is required once Officer Garney opens the passenger door.
Once he opens the passenger door?
Yes, that's when we locate the seizure.
Okay, so
I'm sorry.
Once he opens the passenger door, is that when the seizure starts?
Yes. And I'm sorry.
No.
I just wanted to add to that that of course doesn't make what happened before irrelevant, that of course the shadowing, the following alongside, all of that was starting to escalate and intimidate So even though the seizure didn't happen before, there was certainly an escalation, very quick escalation. There was the intimidation of that objectively any reasonable person, and certainly a young black male, would feel, being shadowed, then alongside. Both officers testified he clearly did not want to talk to us. He was responding, but he did not want to talk to us. He kept his eyes either straight ahead or darting all around, any direction but us. He kept walking. Officer Gaziano testified that he actually picked up his pace. He did not want to talk to them, and so that's why when he opens the passenger door, it's clear that, you're not talking to us, we're going to make you talk to us. That's why that's where the seizure is located. And even if it happens, even if this court finds it happens a bit later, so for example, when Officer Garney gives chase, so
So how does that work, though? So you say under Warren, we can't consider the fact that your client ran, right? So should we not consider that the police ran after him, too? I mean, is running on both sides irrelevant?
No, not at all, because
But if your guy runs and we can't take that into account, how does that work?
The law, I'm sorry, the law is clear that pursuit is a seizure.
No, it's not.
Well, let's stop there for.
Go ahead.
That has always confused me in some ways, and I understand they're considered to be problems with Hodari D from the federal circuit, the federal position. But that's a very simple rule. You're seized when you submit to authority, one way or the other. So wouldn't that be an easier way for us to analyze this?
No, I would certainly not recommend that this court go back on its case law under Article 14, whatever the federal rule is, because any reasonable person, or let's take it from Matta's perspective, what is a police officer objectively communicating to a young black male by getting out of the car and chasing him? It's, I'm going to stop you. You can't go anywhere. So he's running. He wants to avoid that.
Warren doesn't say you can never consider flight, though.
That's true. Warren did say we're not eliminating it, but approach with extreme caution, especially when you have this very scenario of a black teenage boy who is trying his best to avoid this encounter with two white police officers.
So what would you suggest, assuming that the community wants policing, and assuming that there's been shots fired not that far away, and he's the only person in the vicinity, what should the police do?
Well, he wasn't the only person in the vicinity.
Okay.
The officers clarified that no, we're not saying there was zero pedestrian traffic. There was minimal. And also in, I believe it's Menaeus, where the court looked at, or no, I'm sorry, it was Warren itself, I believe, where it said, when you've got this sort of narrow geographical area and you're riding around for just a certain amount of time, you might not come across that many people, even when it's cold. So Warren actually looked at that very piece and said, that doesn't add anything.
Can you factor DePisa into this now?
So let me turn to my DePisa notes. DePisa is a foreign case.
Can I clarify something before you
Yes.
jump on DePisa, if that's okay, Justice Cypher?
Sure.
So your position is that when he opens the door, that's when the reasonable articulable suspicion stops, right? You need reasonable articulable. But you also then said it could have happened later, i.e. when the police officer gave chase. But nothing really happens to change the composition of the facts between the door opening and the chase, because it happens
Exactly.
right? So it doesn't really matter in this case.
Well,
So
I'm
under
sorry.
your view, we look at what the police knew at that time to see whether it was articulable suspicion.
Yes, I agree. But may I just,
Sure.
the reason why I do argue that as an alternative is because the Superior Court, if you actually look at page 130 of the record appendix, which when I started reading it again, I found that very important. the court seems to take a lot of stock in the flight.
Sure,
That-
sure.
that seemed
We
to
we would have to,
change.
on your view, we
Right.
would have to take the flight out of it and then look to see if there was reasonable articulable suspicion.
Correct.
Which now leads us to Justice Cypher's question about DePisa and why we should backtrack from DePisa.
I'm sorry?
Why should we overrule DePisa essentially?
It is consonant with DePisa. This court would not have to overrule DePisa at all. In DePisa, there was a straight-arm gate. So a straight-arm gate looks especially strange because you've got one arm stiff to the side, and then this defendant had the other arm free. So he's clearly like holding something down that, that raises their suspicion. It might be a firearm. He has,
That's here or that's in DePisa?
that's in DePisa.
Okay.
And then, in other words, there's not just the so-called blading. And in DePisa, it was actually repeated blading. Here, there's really only one time they say he quote, bladed. So he's got the repeated blade, he's got the awkward motions, he reaches into his right pocket. I'm sorry, I'm still talking about DePisa. He reaches into his right pocket, he keeps turning away from them. Then at this is a crucial moment, the police officer sees, quote, something heavy in the pocket. And even with all of those facts, which are very different from the facts here because there's no bulge, there's no outline gun, et cetera, even then, this court said this is a close case. So when you have far fewer facts, this court should absolutely reverse.
I'm sorry.
Is your view that, there are various kinds of flight. There's a sprint and there's a jog. I get the impression here that this was a sprint.
It was a full sprint, yes.
Okay, so both by the defendant as well as by Officer Geary or Garvey, correct?
Garney,
Garney, okay. So this is different from cases in which they're sort of jogging and sort of surveilling them. This is a full sprint. I thought there was evidence that the defendant's hands were in his pocket as he was running.
Yes, but that was, that clearly happened after, or I'm sorry, the observation of that very thing happened after they gave chase, or sorry, after Garney.
How soon after? Are you saying that is within the scope of our consideration with regard to reasonable suspicion or beyond the scope?
Well, it depends on where you locate the seizure.
Well, I understand, and that's why.
Right, but
That's
but if you locate the seizure where, I know the Commonwealth disagrees with me here, the way I read his decision is he seems to locate the seizure right where Your Honor says that, he's running awkwardly, he's got his hands still in his pockets. That seems to be where the court locates the seizure. But even then, even if you locate it there, we would absolutely not concede it. It's still winter and it's
Right, but
single digits and
you can question its weight, but generally, when you're running at a full sprint, your hands are extended. If you're going to be, your hands are not generally in your pocket if you're in a full sprint. So I don't claim that it bears a great deal of weight, but it bears some in terms of the calculus. You would agree that if we were to find that if that were within the scope of RAS, of a reasonable articulable suspicion, they would bear some modest weight.
I would give it only a hunch. A hunch is something amiss with this teenage boy.
Now, what do
why
we
is he doing
do?
it that way?
In DePina, we said that the gravity of the crime and the present danger of the circumstances may be considered in the reasonable suspicion calculus. I take your point that if there had been no shooting and all we had was these officers seeing this individual on the street, that all that you describe would fall short of a basis to stop him. But we do have a shooting minutes before. We have somebody who is down. We have multiple shots fired. We have reasons to believe that it was a gang-related shooting given the circumstances of multiple people fleeing a shooting in a neighborhood with a history of gang violence. Doesn't that change the calculus from a situation where somebody simply sees a 17-year-old black youth on the street?
Well, I want to be clear that there was, of course, no information that this was at all gang-related. In fact,
Well, but can't one infer that from the circumstances here? We have a history of gang violence. It's in the neighborhood where there's gang violence. 3 individuals fleeing after a shooting. It's not a, doesn't sound like a bank robbery. It doesn't sound like a domestic. It could be other things, but
well, as this court has said time and time again, that same with now flight with Warren, certainly high crime area needs to be taken.
I'm not
with
saying high crime
extreme
area.
caution.
I mean, I'm saying an area which has a history of gang violence and a crime occurring in that context in a circumstance which is consistent with a gang shooting. That's different from saying it is simply a high crime area in general.
I see my time is expiring. May I
That's all right,
respond
you
to
may
that?
answer.
Because this is really important. First of all, the suspects were fleeing in the opposite direction of Mr. Evelyn. So when you talk about individualized
You say
suspicion.
that, but the judge, I shouldn't have, the judge made a finding that he credited the testimony in the entirety of both officers, and they said that they may have misheard it, but don't we need to take the fact that they honestly were under a misunderstanding as to where they had fled? So in their mind, the persons had fled in that direction. Don't we have to accept that that was what they had in their mind?
Well, that's not the objective reality, though. I mean, it certainly was in their subjective mind, but that wasn't the objective reality. But even if, let's say, the objective fact, based on their understanding, is that they were fleeing away from Adams Street. If I commend to you the Google Maps that were submitted as suppression exhibits, there are so many directions you can go, even that way. So many roads, there are houses, there's any number of cars these suspects could have gotten into. And what's remarkable about this case, when I was trying to distinguish this from other cases, Warren also, at least in Warren, there was some kind of description. It was, 3 black males, one had a red hoodie, another had a black hoodie. This case is remarkable, and there's
But
nothing.
that's relevant if we accept the premise that opening the door starts the seizure. If a police officer just opens the door, what other factors go into that to make it a seizure? I mean, that can't be the only factor.
Can I add to that? Doesn't MATA, which is our last statement on this, inconsistent with your argument that opening the door is enough? MATA, they're trailing this guy. They ask him, hey, come over here for a second, and they head towards him. That's not enough, right?
I'm sorry, may I answer Justice Cypher's question first, and then maybe you can remind me?
No, he'd prefer you answer his question, but you go ahead.
Okay.
It's okay when she
But
interrupts me.
pre-MATA-
It's okay when she interrupts me. She just doesn't want me to interrupt her.
So the general case law is, and this is where Commonwealth versus Barrows comes in, so it's not just, he didn't just sort of pull up and open the door, right? There was interaction beforehand. And so what the court has said is, and again, I've looked at all the cases, and pretty much all of them that I can find are the suspect, the individual, is responding in an affirmative way. Hey, what's your name? My name is Mr. Daly. Maybe they're a little uncomfortable, but they are consenting to this conversation. My client was not. And then, I'm sorry, so MATA.
MATA's, hey, come over here for a second.
Right.
2 men get out of their vehicles in unison, and the defendant begins walking away. As the defendant, this officer says to substance, hey, come over here for a second.
Right.
The officer and the defendant locked eyes, and then the defendant began running away. So we certainly don't find it before he runs in MATA, right?
Oh, well, that's right, but that was all the context that the court had. It was just that single question or statement, really. Can I, come over here for a second? And it was for a second. It wasn't
So
like
we have all
that was
we
it.
have is, hey, can I holler? What's the holler at you? I can't remember.
Hey, my man, can I holler at you?
Right. So and how is that different from MATA before the running? I mean, I see where your point, although I don't necessarily agree that running is irrelevant, but I see your point once they start running after him. But I don't Because that, to me, under MATA seems like a show of authority, but I don't get how just opening the door is anything.
Because the tell in this is both officers testified, he didn't want to talk to us. We knew he didn't want to talk to us. And we kept following him anyway. We
have a bunch of
asking him.
cases where trailing has been okay, right? Lots and lots of cases.
Well, trailing, but again, this is trailing plus, right? So
Not
this
trailing plus until they start to run. When they start to run after him, I get it, but I don't see it
Right.
before then.
Can I ask one more question, Chief, perhaps?
I got one more too.
With respect to a big part of the case, it had to do with the expert testimony.
Yes.
Okay, and I know you want to address that. I want to give you that opportunity.
I'm
here.
at the court's disposal on it.
Right, so on the expert, the Judge Raschuti below allowed the expert to testify.
Right.
And then made 3 particular findings. And the expert, my memory is, testified as to the unreliability of blatant and objective criteria that the police use. And also, he also expounded on, she expounded on what we had written in Warren regarding racial profiling, right? But Judge Raschuti listened to that testimony and then found it not credible for 3 reasons. Why should we disregard his findings?
Well, he found it not helpful. Not that it wasn't credible, just that it wasn't helpful. Well, one is, so there seems to be a misunderstanding that the defendant is arguing that there needs to be this, and that's his first point, that, quote, there's no requirement that conclusions drawn in the real world by police officers based on their training and experience satisfy a scientific standard of proof. I mean, I agree with that. It's just that, this kind of testimony, these studies, should set off alarm bells about whether police officers, I'm sorry.
But if he hears the description of the study that was done at Iowa State, I think it was, and then about the people walking down the quad and police officers, and says, that's a very small sample, and our experience in the identification realm over the last 20 years is certainly up the ante on the social science, but we're not really there on this kind of embryonic study. Isn't that what he's kind of saying?
When does he say that? He says that the literature does not exist, but that really redounds to the defendant's benefit because it's the Commonwealth who is the proponent of this testimony, this expert testimony by these police officers. They're using their specialized knowledge with their training and experience. So it's really on them to show that their training and experience is based on some kind of objective criteria, or at least some kind of makes sense. But all they have is a PowerPoint, and so what this study kind of brings out is that, whoa, maybe our assumptions aren't right. Our assumptions that police officers are better than lay people.
But if the judge had said, I absolutely agree with that, and this expert is 100% right, then the Commonwealth would be arguing something different, but that's not what happened here. So how do you get around the judge's factual findings after hearing all this evidence that this testimony wasn't helpful? You want us to say that was a clearly erroneous finding?
Well, I'm saying the unhelpful, it struck me as more of a legal conclusion, so it seems like more of a either de novo or abuse of discretion. But it certainly is an abuse of discretion when he's not, or the court is not only just setting it aside, but is not then turning to the Commonwealth, basically, and saying, okay, maybe I don't find this all that, definitive, but, this does raise my alarm bells, my heckles, if you will, about whether the Boston Police Department's training and experience is really all that competent or reliable, and that should absolutely, that's always weighed in a reasonable suspicion analysis. And he just didn't do that, so that would be my response to that.
Chief, could I?
Sure.
Thank you. Ms. Barnwell, before you sit down, I have a couple of questions that I expect Ms. Campbell's going to bring up, and I'd just like to have you have an opportunity to respond to the inevitable questions. The first one is going back to Commonwealth versus Stout and Powell and Franklin and the issues of what flight means. And the Commonwealth inevitably is going to say that we can consider the flight because it preceded the pursuit, and Commonwealth versus Warren is an issue of weight, and certainly the judge should take Warren into account and discount the flight because of Warren, but that nonetheless, there is flight that gets built into the calculus of reasonable articulable suspicion if opening the door was not the moment of seizure. Could you respond to that argument that we'll inevitably hear?
Well, as this court recognized in Warren, the case law preceding it, there, as Your Honor pointed out, there are cases that essentially imply consciousness of guilt from flight. And Warren, I think, made two critical points about the, quote, factual irony in the case law. On the one hand, the court says, you can avoid the police. You don't have to engage with the police. That's fine. But on the other hand, if you avoid the police, or you avoid them in certain ways, you're nervous, you don't look at them, you flee, then actually we're going to hold that against you in the reasonable suspicion analysis. And so Warren says, again, approach with extreme caution. We're not eliminating it, but we don't want to essentially trap young black men in Roxbury, right? On the one hand, I don't have to engage with this white Boston police officer. On the other hand, a court later on is going to see me as a criminal or see me as suspicious because I didn't engage with the white Boston police officer.
So if I can just sort of recapitulate, your argument is, well, no, our case law does allow the judge to consider the flight that preceded the pursuit, but considering these circumstances in Commonwealth versus Warren, it just doesn't add a lot.
Exactly. And again, and the second point of Warren, of course, is it's just as likely that this young black male is trying to avoid the recurring indignity of being racially profiled.
Okay, and then the second thing is when you were being asked questions about what the Mr. Evelyn was doing as he was fleeing at this point in time from the police and holding onto something. Of course, if the seizure had already occurred, then we don't really take that into account. But if there's an argument that the seizure hadn't occurred, the judge's finding also was that that he tried to reach into his pocket and take something out. If you recall, he tried to draw an item out of his pocket while he was still running. You remember that finding?
I do. That was in the fact finding.
Right.
And frankly, what confused me at that very point, the Commonwealth pointed out, there's one point where he says the seizure happened at the end of his run. Then there's like 4 pages. I'm sorry. I'm sorry. And 4 pages later, he doesn't even mention. I mean, you would think that's an important fact. He's trying to draw something out. He did the command, but he doesn't locate it there. So, I mean, if he's trying to draw, if the seizure is even beyond the sort of awkward running, and now we're in the space of he's trying to draw an item out, I understand I would have probably a difficult road, but I would still not concede it because we still don't know what that item is. He doesn't see an outline of a gun. He doesn't see a holster. He doesn't see anything like that. He's just, it's kind of vague.
Right, thank you.
Thank you.
Before you leave, one more question. Just to clarify,
Again, that you're
I
supposed to-
understand, that's all right. Well, I'm sure Ms. Bassil will give you extra pay for the extra pay.
She's giving me coffee later. Thank you.
That's good, that's good. I understand the argument that we made in Warren that when one evaluates the inference to be taken from flight or evasiveness, that one can take race and let's add youth to that calculus to say that we must recognize that there's a reason why a black youth may run or be evasive for the police that may not be present for an old white man. Where I have some trouble, though, is are you asking us to say that in terms of the timing of the seizure, that the timing of the seizure differs between whether you are a black youth or an old white man?
In this case, let me be clear, in this case, it does not, Mr. Evelyn should prevail at the opening of the passenger door, whether or not the court takes into account his race and age. But it certainly should matter. If it's a reality for young black males, so Warren is saying This is the reality, okay, for young black males in Boston, period. That reality is the same under the totality of the circumstances, whether we're talking about seizure or whether we're talking about behavior.
But
Okay, but think of what that means. I mean, that means that any time a police officer wants to speak to a young black male, that, according to your understanding, that would become essentially a seizure, and you could not do it without reasonable suspicion. But if this same person were an older white person, you could have that questioning.
Well, in JDB versus North Carolina, the United States Supreme Court confronted that very question and said, and the response is, look, it's not always going to be dispositive, the individual's age, and in this case, the individual's race. It's not always going to be dispositive. In MATA, for example, it may not have turned anything because there was, again, no other intimidating context other than, hey, come here for a second. That was it. So it's not always going to be dispositive, but there are important circumstances. This is a totality of the circumstances test. They should be part of the circumstances, absolutely.
So that the timing of a seizure depends on the race and age of the individual who is being seized.
Those are factors to be considered along with everything else,
The race of the police officer?
I'm sorry?
The race of the police officer?
That should also be considered, yes.
So so the same circumstances, same conduct, different timing of the seizure depending on all these issues of race and age.
It could in a particular case. Again, in this case, it doesn't really matter whether the court, I mean, it does matter, let me be clear. It does matter whether this court considers race and age, but the calculus should still be to Mr. Evelyn's benefit that there's still a seizure when he opens the door.
But what's a police officer to do? I mean, it's hard enough now for them to understand when they need reasonable suspicion to stop somebody, as opposed to simply saying, can I speak with you? But if you're right, then the officer is going to have to look and evaluate the race and age of the person. And how is the officer supposed to know then whether or not the police officer can seek to question that person, because it may be a seizure if he's black and young, but not be a seizure if he's white and old?
So certainly, you know, the court need not hold that the police officers must be certain. The JDB versus North Carolina standard, I think, works really well in this context, which is what was reasonably apparent to an objective officer. And in this case, they both testified. We saw a young black male. He was tall, and you know, they didn't even ask for his license for the firearm because he looked so young. They also know or should know that their department has this very, very troubled history of racial discriminatory stops. That's going to create a different dynamic than if they're in, you know, Newton talking to an old white man.
So if we have a patrol car driven by two black police officers, you're telling us there's a different set of rules?
No, not necessarily. The statistics.
You just told us that the race of the police officer matters, so we would have a different standard if two black police officers were involved here.
What about if the defendants are Hispanic or Cambodian, or are we going to have different rules for each nationality?
Well, again, it's what's reasonably apparent to the police officer. I don't know the statistics. Do they have do they have a history of racially discriminatory stops against?
But I'm just trying to understand, are we going to have some kind of difference, as Justice Gaziano saying, if we have black cops and black defendants, or white cops and Hispanic defendants? I mean,
how about an undocumented person who escaped a totalitarian regime?
I would say only if the officer knows that. I mean, if that's reasonably apparent to the officer. If it's not reasonably apparent to the officer, then it's just not weighed. Is how I think the balance happens in JDB, which this court should apply.
So what is the test for your seizure? When does it occur? Just sort of not here, but in general, when does a seizure occur? Is it when a reasonable person feels unfree to leave?
So MATA has, I suppose, somewhat, well, MATA says it's not really changing anything, but yes, I think the test is whether a reasonable person from the defendant's position, in this case, he's a young black male, would feel free to leave.
No, it would be,
Reasonable person, excuse me.
that's not it, not whether they'd be feel free to leave, whether
we've
objectively
changed that.
communicated, the officer would use his or her police power to coerce the person to stay.
I'm sorry, what? Could you
Correct,
repeat
and
that?
so in this case,
Yeah, sure. Whether or not the officer has, through words or conduct, objectively communicated that the officer would use his or her police powers to coerce the person to stay.
So that has no relationship to who the person is, who's
well,
being-
so in this, so it, I mean, the problem is, right, is that we often talk about this as a silent movie, and it's like watching this as a silent movie and then pretending that he's not young and black and pretending that the police officers aren't white and all of that entails, and that the film isn't filmed in Roxbury. We can just sort of have an abstract. I mean, that doesn't make any sense. The totality of the circumstances should absolutely take that into account. And as to Matta's compelled to stay, here's the situation is that the officers one officer keeps, asking Mr. Evelyn questions. He does not want to talk to them. Okay, this is what the officer objectively communicated. You don't want to talk to us? You don't want to talk to us? All right, we're getting out. We're going to make you talk to us.
Objectively.
stay.
I don't know what objectively means in this situation. That's my problem. What are we talking about? Objective from what point of view?
Well, I would submit it's the reasonable person standard. I have advocated for modifying MATA, not that it would have to reverse anything in MATA, but that it should be, really these two things are intertwined. What is the officer communicating, and then how would a reasonable person perceive it? There's no way really to divorce those two things. And so, and I gave the example of, you have a sort of easy example. A police officer goes and is talking to a person walking down the street. An officer goes, sees a woman in a wheelchair and starts talking to the woman in the wheelchair. I mean, the woman in the wheelchair is going to have a very different experience, right, than someone freely walking.
But I mean, that's the point. I mean, how would we judge it from the point of view of the person in the wheelchair, or the point of view of what is some reasonable person standard that we would presume would be the case for everyone, including the person in the wheelchair?
Well, I think it should be the reasonable person from the standpoint of the woman in the wheelchair.
But you just told me that it doesn't matter if somebody is undocumented from a totalitarian regime and it's going to think there's nothing but trouble.
Oh, I didn't say it doesn't matter. What I'm saying is under MATA.
No, you said if the police officer doesn't know, it doesn't matter. That was your answer to the question. I mean, as far as from whose perspective?
Well, as far as when the seizure was. If the officer doesn't know it, or if it's not reasonably apparent, in the case of the wheelchair, it's very obvious that the person's in the wheelchair. In our case, it's very obvious. He's young, he's black, they're in Roxbury. The Boston Police Department has this troubled history.
Okay,
Thank you.
Ms. Campbell.
Good morning, and may it please the court, Cailin Campbell on behalf of the Commonwealth. With me today is David Bradley, who is the motion prosecutor in this case. We ask you to affirm the denial of the defendant's motion.
Why shouldn't the
express.
age and race of Mr. Evelyn here go into, as a matter of weight, similar to Warren, into how much his conduct in avoiding the police matters in calibrating reasonable and articulable suspicion? Why shouldn't that be considered by the judge in his or her findings of facts in determining how much weight to give that behavior?
So insofar as Warren recognizes the realities in Boston, I say it could be, right? And it should be. I think it's important to clarify what Warren stands for and what it doesn't stand for. And I'd point the court, first of all, just factually, it was 30 minutes from the report of the crime, 2 miles away. But I would point the court to page 538, in which it says that evasive conduct, so it's not just limited to flight, it's evasive conduct, and I'm quoting, is a factor properly considered in the reasonable suspicion analysis. Jumping down, it says evasive conduct in absence of any other information is insufficient to support reasonable suspicion. So you can't just point to the flight and say, That's what supports the reasonable suspicion. And I think factually here, you can distinguish Warren, almost even if you were to place the stop as early as Officer Garney opening the door, there are still objective things that the officers have.
Do you win if we do that?
Yes, because you have, I think it's important, though not dispositive, as DePina says, that they're investigating not only a shooting, but a shooting in which an individual has been shot and is in life-threatening condition. Not only that, the specific testimony from the officers, which was credited and found by the motion judge, first appearing on page 5 of the opinion, is that Officer Gaziano had seen no pedestrians on Harrison Avenue, and that he had seen no one on Melnia Cass.
You're not asking us to overrule Warren or Menaeus, correct?
No.
Because what those cases do is describe the realities of racial profiling, but they also talk about the Hobson's choice in that if someone is free to leave, they have to be free to leave. So you can't take that in part of the calculus for reasonable suspicion, correct?
Correct.
So
But it's not.
It's a hollow right if they do leave and you grab them and arrest them.
Yes, I can understand that argument. I think here that's why I argue, and I argue it in my brief the way that I do, is even if you were to consider this at its earliest moment, there's reasonable suspicion at this moment. I think, looking at the MATA standard, it's sort of the juxtaposition between the two. And that's why I think it's important. Even in Menaeus, they talk about how officers, especially when they're investigating violent crime, such as happened here, need to be able, that is also a
But
factor.
Menaeus, we had a police officer, there was a shooting case, he goes up to a group of kids, he talks to a bunch of them, and then Mr. Menaeus says, I don't want any part of this, just starts to walk away.
Yes.
And we said, once the police officer chased after him, he was seized.
Yes.
And we looked to see whether there's real suspicion, which it wasn't.
Correct.
At that point, right?
Correct.
So, I know what you argue in your brief, but are you saying that the judge was wrong in his seizure analysis as far as at the end of the event, almost at a Hodari D point? Are you saying, or when are you saying that the seizure occurred?
No, I think the judge is absolutely supported based on the case law to find the seizure when he does. I understand for purposes of sort of trying to figure this out in argument, placing it as early as when Officer Garney opens the door. But I think if you look at MATA and the standard articulated in MATA, which is the words or conduct objectively communicating that the officer would use his police power to coerce an individual to stay, Judge Raschuti didn't have the benefit of that standard at the time that he made his factual findings. I don't think it changes the ultimate outcome in the case, but I also don't think it's fair to look at his analysis.
But what inference can be drawn by the fact that he says the holler thing, the defendant keeps walking straight ahead, doesn't want anything to do with the police, and then the door opens, and as Ms. Barnwell argued, the only message that can be conveyed from that is you ain't got no choice.
And even if you were to construe the moment of constitutional seizure at that point, I think there are significant other facts that support reasonable suspicion.
What are they?
Sure, I'll tell you. As I just mentioned, it's the fact that there has just been a shooting, that there's been a victim shot. It's 13 minutes away, and it's a half-mile away. The specific testimony of the officers, which was found by the judge, and this is on page 5 of his decision and page 8 of his decision, is that the defendant was the first person that they saw in the vicinity of this crime.
They didn't have a description of anybody, did they?
They didn't have a description of anybody, no.
I think it was more than one shooter?
Yes, there was a report of
So
three
having
individuals.
Just sort of, you could look at it as just, what basis would they have for stopping this particular person?
Sure, and if that was the only fact, I could understand, and I don't think I'd be able to make the argument that I am now, but
Facts, though.
sure, the other facts are that the officer, and this is credited testimony, that the location of the shooting suggested to the officer that it was in an area where an active gang feud was going on, and that's why he went, in addition to the radio dispatch call, but that's why he went in the direction that he did. But even more so than that, when they first see the defendant, and I think that this is important, it's 13 minutes after the shooting, they see his right hand, and this is credited by the judge, clutching an object in the defendant's right pocket.
See this right from the beginning?
What?
They see this right from the beginning?
Right when they pull up.
decide to pick him out as somebody to talk to?
Correct.
They've
Correct.
They've already seen that.
Yes, when they see him, when they pull up alongside the sidewalk, the testimony is they see that he has his right hand in his right pocket, that he's clutching an object. Not just clutching an object, but the specific finding is clutching an object that was consistent with the size of a firearm. And the specific testimony was that it's consistent in size and scope of a firearm.
What does that mean exactly? I mean, I'm walking to work today in a winter coat, and I got my cell phone in my pocket. Does that meet that description?
I would say it depends on how you're holding it, and again, this is not the only...
I got my wallet in my, I mean, it's winter, right?
Absolutely.
It's winter, he's in a coat, and he's got something in his pocket.
Sure, but
Seems, I don't know how much that adds.
But no, I think that adds a lot because it informs the blading observation, because it's not just that, it's not just...
I get the blading is something different, but I'm just, the object in the pocket in the winter, I mean, almost everyone here probably walked to work today in a big coat with their hand in their pockets. I just don't know.
Absolutely, but looking at that one, that doesn't mean that you can't consider that factor, right? If I only had that factor, it would be a different argument. But looking at this factor, and I also think it's important throughout the context of all of this and considering Dr. Sweet's testimony as well, to remember that we're talking about reasonable suspicion. So there's no requirement, I mean, even if you were to elevate it to probable cause, that the officer's observations be actually accurate. There just has to be an objective, factual basis by which they make the observation that they do that supports sort of...
I should know this, but forgive me, did the blading occur before or after the door opens?
It happens before, and the observation is that they see the hand in the pocket clutching the item, which is consistent with the size of the firearm. They then follow, and then that's when they notice the blading, which...
Because he can see them, apparently, so now he blades his body to conceal the weapon.
Correct. And I think it's not, that's where, you know, the amicus and my sister's brief kind of ignore. I think you can't ignore the item in the pocket and the blading and sort of the timeline of these events as how they occur. I also think it's significant that, you know, this is not an instance, they pull alongside him, they follow him, they roll down the window, they say, "Can I holler at you?" And he responds to them, and he says, "For what?" And they explain to him there was something that happened in the neighborhood. We want to see if you heard or say anything. And the testimony was that he mumbled something that they couldn't understand. And it's that point that they decide to get out of the car. So this seems different to me than someone who absolutely is not engaging with the police. He does respond to the questions that they ask.
Yeah, but he clearly doesn't want to.
Yeah, because then we get the Warren factors kick in at that point, though. The I don't want to engage.
Sure.
That triggers Warren.
It does, but I think it's different than sort of looking at a case of someone who's actively rebuffing any attempt for the police to talking to them or trying to absolutely leave at the first question running away.
I guess when you say someone keeps their, you know, the police make a big deal that he locks eyes and he won't engage.
Sure.
He gets his eyes fixed, and they find that nefarious, but that's also indicative of someone who doesn't want to talk to them.
Absolutely, and while if that was that factor alone, I couldn't be making the argument that I am. It's not that factor alone, it's the totality of all of the factors together. And so I would suggest if you look at a case like DePisa, I mean, this is so much more than DePisa because you have an actual, not just shots fired, someone who's shot, and then objective criteria which they look at. I will say it again, the right hand in the pocket, clutching an item consistent with a firearm, followed by the blading, and the evasive behavior, which even if you open the door, that supports reasonable suspicion.
Can you address the judge's finding that the opening of the door was appropriate from an officer's safety perspective?
Sure.
And then the judge further finds that Evelyn thus ran on his own, not occasioned by anything the police did. That doesn't sound correct.
So there was testimony from Officer Gaziano, which I keep on saying wrong, but that based on the observations they made, and this again goes to the subjective intent of the officers, so I'm not sure how much it actually plays into the objective criteria which are to be considered. But to answer your question, there was direct testimony from the officer that based on the observations that they made of the hand in the pocket and the blading, in conjunction with, you know, the reason why they were in the area, they believed that he could have a firearm, and that the officers thought that if he were inclined to pull the firearm out and use it, they were in a bad tactical position. So it would make more sense to get out of the car. for that reason.
So, do you agree that if there had been no shooting that night, if it was a quiet night, that all the inferences which they drew from his observation would not suffice for reasonable suspicion?
That's a tough question.
That's why they pay you the big bucks.
Correct. I mean, it would depend if we have the same gang activity, recent shots fired.
I'm saying it's a quiet night.
Quiet night. Then probably not. But here, what you have is the reason why they're in the area, and the recency of the shots fired, and someone actually shot.
You also have Alvarado issues too.
Correct. I mean, we don't need to reach that question, obviously, because we have the facts that we
Well,
have.
it bears on the weight that we are going to be giving. I mean, it matters whether or not we're going to be saying that all these, the blading and the evasiveness and the flight, especially for a young black male, would suffice to
Correct.
enable a police officer to do a stop. That's important.
It absolutely is important.
And so that's why I'm asking you whether or not you're saying on these facts that would suffice in the absence of there being a nearby shooting.
No, and I would say you almost can't divorce I guess I will say the critical fact in this instance is that there was a shooting 13 minutes before a half mile away.
And let me follow up on that. Everybody will get their chance. Do you also agree that with regard to Warren, in terms of the inference, the weight of the inference to be derived from evasiveness and flight, it's appropriate for us to include not only race, but also youth? That when somebody is a young person of arguably any race, but certainly an African American, that the weight to be given to evasiveness and flight should be less than for an old white man.
And I guess my answer to that would be, it would depend on the facts of the case. So my sister brought up JDB, and the amicus almost solely rely upon JDB to make this argument. But I think the actual limitations which are contained within JDB are important, because the first one is that age is to be considered so long as the child's age is known or would have been objectively apparent to the police. And in that case, it's not a question, because it's a 7th grader and they take him out of his 7th grade class. He's 13 years old. It gets difficult when you have here, I mean, and even in JDB, they say sometimes age would be an insignificant factor, and they point to Yarborough v. Alvarado, in which there's a 17-year-old. And so what objectively appears to the officers, I'd say that's murky. That becomes murky when you have an instance as you have here, where you have a 17-year-old who appears is over 6 feet tall.
I thought you'd answered the same question that the chief just asked when I asked it. Yes, I mean, when you're evaluating all of that behavior, and how much weight it adds to the reasonable articulable suspicion calculus, that you do consider race and age as a matter of weight, as you would with Warren at that moment.
As a matter of weight, it becomes interesting, right? Because
I just want to make sure that he's getting this, we're getting the same answer, because it's the same question.
and maybe I didn't understand it to be the same question. That's probably on me and not on the way that the question was asked. But, you know, in the considerations, it's Justice Lenk asked a question as to whose perspective it's considered by. Is it the person who stopped, or is it the police officer and their behavior? And I think that's sort of the crux of it. And when you think and you look at the case law as to the purpose of the exclusionary rule, it is to deter future unlawful police misconduct, thereby effectuating the guarantee of the Fourth Amendment against unreasonable searches and seizures. So it is focused at the police conduct and whether it's reasonable or unreasonable. Sure, that may be informed by the totality of the circumstances, and actually, in actuality, it must be, in a warrant that recognizes sort of realities regarding race. But you also have to consider what would be apparent to a police officer when they're investigating crime, and when they're investigating a serious violent crime such as what happened here. And what you don't want to happen, and what is really the harm in sort of expanding this too far. Again, I would point to JDB where, you know, that the Supreme Court and the appeals court, and there's no case from this court that I could find, sort of analyzing JDB and explaining it, but it talks about too much individualization in looking at the individual characteristics of an individual. In this context, it's Mirenda, so it's for the purposes of custody. But importantly, the court, and the Supreme Court does so, says that standards should avoid burdening the police with the task of anticipating the idiosyncrasies of every individual, divining how those particular traits affect each person's subjective state of mind. And that's where, you know, there has to be a balance between investigating crime and a defendant's rights. And we're not suggesting that there shouldn't be that balance, or that race or age would never be considered in the totality of that balance. It's just that it has to be a balance. I'd say here, given all the factors that I've pointed to before, the fact that, you know, there was a shooting close in temporal proximity and geography, based on the specific observations that they made of this defendant, even taking into account his youth and his race and the history of Boston and policing, which is recognized by Warren, there still is reasonable suspicion to support the stop.
That was what I was going to ask you. If you put aside the evasiveness and flight, do you still win?
Correct.
And you're saying you do?
Correct.
Okay, so we can take that out of the calculus completely and you still win in a court.
I don't think you should, and I don't
And I
think Warren
understand that,
says
but I'm saying that you're saying we could.
you could. Yeah,
How would
absolutely.
you would still win, so that doesn't matter.
Correct. I'm more forward-looking in seeing
Yeah.
how you sort of engage in this calculus going forward on different facts that
I
aren't
understand
as-
that. I'm
as
just saying
strong
here.
as
But
this.
if he had, I don't mean,
No, I just wanted to make sure. I
if he
understood.
had, if he had just kept walking, I'm just trying to understand, if he'd kept walking and we take Warren into account, I'm just, you know, and I think it's a lot harder. When he sprints, that seems to me significant. But you don't seem to think you need that. But you don't have a lot except for maybe blading, and I'm not sure what blading means really. I mean, I get what.
See, I disagree there with
Okay.
the a lot, and I think
Okay.
you can't divorce it from the
No,
crime.
I understand
all
this
of
is a shooting.
Absolutely, but, you know, I understand your concern given.
Let me change the facts. It's a 75-year-old man or woman walking on the street with his hand in his pocket. Got a hand in his pocket. It's cold outside, and he mumbles to the police or she mumbles to the police. You have enough to stop that person? If he doesn't run, she doesn't run?
It depends on what the testimony is as to the hand on the pocket, right?
Really? It's a 75-year-old woman, and you got enough to pull her over? Come on.
No,
Really?
but I think the facts here matter, and I'm not arguing sort of anytime anyone has their hand in their pocket walking down the street that there's reasonable suspicion to stop or search them. I definitely don't think that that's the case, but I don't think that this case boils down or distills to those facts, especially in light of, you know, I don't want to be repetitive, but the sort of, as the court recognized in both Menaeus and DePina, that the crime under investigation and the fact that it's a violent crime and the fact that it's 13 minutes later in close geographical proximity with the observations that the police do make, that is essentially in the only context in which
And
this
I
is to be
guess it's the word
considered.
blading, that it's better to say what happened rather than use the word blading. What happened, that's the problem, it's a loaded term, is that in that context, he turns the right side of his body
Yes.
away from where the police car is coming along next to him.
Absolutely, and if you look at the testimony and the judge's factual findings based on that testimony, the officer says he's heard it referred to as blading, but then he describes the specific observations that he makes.
The word blading doesn't do anything for me. It's what he actually allegedly did.
And what
Yes.
did he allegedly do? Describe it. What is he doing as he's walking? He does what?
Sure. As he's walking, there's a hand in the pocket, which we won't get into again.
Right.
And there is, I want to make sure I'm being precise. his hands remain in his pockets. The officer says he knows it as blading, but that he turned the right side of his body unnaturally away from the police car to the left so that it was not facing the side of the police car.
Ms.
Isn't the core issue here ultimately for us to decide whether or not the police officers are obliged to let him run away under these circumstances?
Obliged to let him run away?
I mean, because if it turns out that we say there was not reasonable suspicion to stop them, then they were obliged to let him run away.
Yes, yes.
I'm not sure you said that before, though. I need to get at where your seizure moment is. Because you said that the seizure was when the police basically take out the gun and say, stop. And okay. And maybe that's it. That's certainly a seizure.
Absolutely.
I think it's earlier than that. And that putting into account that our cases in Franklin, that are not exactly clear on what pursuit means for the purposes of stout.
Correct.
But putting that aside, in this context, considering everything that's happened, if they had pursued him before he started to flee, I'm not sure we could really, count that. But he takes off, and then they pursue him. And my question is, when they start to chase him under stout, isn't that the seizure?
Well, no, and I think it's interesting, too, looking at the new articulation of that under MATA and the objective communication as to whether he would be compelled to stop. I would say that changes the analysis, correct? Because if you look at, a case like Messiah Franklin, running after an already running person because there was no additional level of seizure, that's how that came out. It wasn't the same sort of standard that exists now. Objectively communicating, I say objectively communicated once you start running after somebody. I would agree that under MATA, that probably is the moment of seizure.
We have to apply MATA now, don't we, to this case? I mean, the judge didn't have the benefit of it, but
The judge did
we
it.
do.
You do, and
So now that MATA exists and is our law,
correct.
when do you say the stop occurred? Upon the beginning of the sprint, or at a later point?
No, well, under MATA, the focus would be on the officer's objective communication through either words or a physical act. So I would say once Officer Garney starts running after the defendant.
No, please.
So basically, you say when the sprint began,
Yes,
when he started to sprint?
Yes.
Not when he left the car, because that would not be enough, you're saying?
on these facts, no.
Because he didn't say anything.
He doesn't say anything, and given where the defendant's body is turned, the sort of positioning of everybody involved.
And then the judge, so the judge may consider the flight because the flight was before the pursuit, but when we take into account how much the flight's worth, we take it into account contemplating warrant.
Correct.
Yeah, all
Correct.
right.
If I may, because I see that I'm over time, just addressing the expert testimony just briefly. I think it's important to look at the judge's findings. He permitted this expert to testify, and he gave it the weight that he saw fit. I think the critical finding is that Dr. Sweet testified that there was no study other than her own threat study, which researched the characteristics of armed gunmen. But when you look at her testimony and the study itself, it explicitly stated that the findings could not be applied to real-life incidents in high-crime urban environments where the consequences of finding a weapon are high and where police are trained in detecting such threats. So I'd say her study, by its own very terms, didn't apply to the circumstances which were before the judge, so that the weight that he chose to not give it in this instance was entirely supported. If the court has no further questions, the Commonwealth will rest on its brief.
Okay, thank you.